like to invite you, ma'am, to share their valuable insights on development in changing times in context of arbitration, and request our guest speaker to illuminate everyone present over here. Just a small request for all participants from my side. If any questions or query arise in between the session, kindly post that question in the chat box. We will consider the questions in the Q&A part of the session and or as per the convenience of the speaker. Over to you, ma'am.
Thank you so much, Mr. Aship Mala, for the wonderful introduction. A very good morning, good afternoon, and good evening to all participants who are joining from different corners of the world. Well, first and foremost, let me thank the organizers, JECRC University and Amicus Curiae Law Club, for inviting me to this national bootcamp on performance and practice of arbitration. I also like to thank the organizing committee, Patron-in-Chief, Dr. Lalit Bashant, the Dean of Faculty of Law of JECRC University, Professor Mahash Kruwald, Event Director, Mr. Samir Shah, and Organizing Secretary, Dr. Namita Jain, for the incredible initiative. Not forgetting the faculty conveners, Mr. Pankaj Awasti, and student conveners for the great coordination. And most important, thank you to all participants for taking your time off in joining this session today and making the event a great success. Well, before I start, I would like to share my slides that I've prepared. So just bear with me. All right. So ladies and gentlemen, following from the earlier panel discussion on the topic of world versus arbitration, now in my presentation, I will share on the development of arbitration in changing times from the perspective of namely to the effects of pandemic on arbitration and recent developments and judgment in the field of arbitration. So arbitration is, I believe, no foreign term to participants today. It is one of the popular modes of ADR in comparison to negotiation, mediation, adjudication, dispute resolution board, and expert determination. International commercial parties overwhelmingly elect to arbitrate their cross-border disputes rather than taking them to court. But why? Well, this is actually because arbitration is generally perceived as a simpler and expeditious way of resolving disputes with universal enforceability. This mechanism actually offers a fairer process due to the neutrality of and independence of the arbitral panel, putting both parties on equal footing. The flexibility of the process itself, universal enforceability of the decision in the majority of global jurisdictions, made the arbitration the most suitable alternative mode of dispute resolution domestically and internationally. Arbitral proceedings, unlike court litigation, are conducted in confidential manner. Parties can keep the details of their dispute and awards private and confidential out of public scrutiny. Aside from that, parties to arbitration also have the autonomy to execute arbitration agreement, enjoy the freedom to choose the applicable substantive law that governs their contractual relationship. They can also choose their arbitrators, appointing one or multiple number of arbitrators, as well as agreeing upon the hearing schedules, language, and venue. As Lord Mastill once said, the great advantage of arbitration is that it combines strength with flexibility. So the essential features which I've highlighted in this screen that I'm sharing right now consist of not only finality, immediate enforceability in all signatory countries, confidentiality, procedural flexibility, technical or legal expertise of arbitrators, has made arbitration all favorable against court litigation and other modes. While the arbitral award being enforceable against the party whom it is made can also be enforced internationally by foreign courts using the 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. So now there has been a growing presence of arbitral institutions. In fact, in India and Malaysia, parties have the option in seeking recourse to either ad hoc arbitration or institutional arbitration, while this is dependent upon their choice and convenience. So ad hoc arbitration actually refers to an arbitration where the procedures is either agreed upon by the parties, or in the absence of an agreement, the procedure is laid down by the arbitral tribunal. Thus, it is an arbitration agreed to and arranged by the parties themselves. In an institutional arbitration, on the other hand, The arbitration agreement may stipulate that in the case of disputes or differences arising between the parties, they will be referred to a particular institution. So all of these institutions have framed their own rules of arbitration, which will be applicable to arbitral proceedings. Some of the prominent institutions which conduct institutional arbitration in India, which I'm made aware of, includes the Delhi International Arbitration Center, the IAC, the Indian Council for Arbitration, ICA, the Mumbai Center for International Arbitration, the Construction Industry Arbitration Council, CIAC in New Delhi, the LCIA India, the International Center for Alternative Dispute Resolution, the ICC Council of Arbitration in Kolkata. Well, amid pandemic, I'm pleased to share that the Asian Institute of Alternative Dispute Resolution had actually launched the AIADR ad hoc arbitration rules on appointment, case management, and financial management with greater flexibility and cost efficiency, which you can see from the screen that I'm sharing right now. So parties can now refer to us for the appointment of arbitrators or to administer the case or even manage the finances involved in arbitration, subject to parties' agreement. So this AIADR ad hoc arbitration rules is applicable for both domestic and international arbitration, and currently available in bilingual, English and Chinese, accessible on AIADR webpage at aiadr.world. So when commercial dispute arise, the AIADR dispute resolution services can be relied on to resolve them as efficiently and effectively as possible. We offer different choices of administrative procedures alternate to court litigation in resolving domestic and international disputes, including the ad hoc arbitration rules, as well as mediation rules. What's more, our services are globally accessible and completely neutral, available to different stakeholders from individuals, private companies, public companies, to state entities. So please allow me some time to introduce to you what is AIADR. So basically, AIADR is the first not-for-profit member-based institute for alternative dispute resolution. It is endorsed by the ALCO, Asian African Legal Consultative Organization, and was launched in April 2018 by His Excellency Professor Dr. Kennedy Gaston, the Secretary General of ALCO. The Institute is dedicated to promoting the practice of ADR through affordable and accessible education and development of the professional services across the continent and worldwide. Our aim is to serve as a platform for members in converging international practices, building capacity, and providing opportunity for all stakeholders of the economy in resolving disputes and seeing projects and investment through with a special focus of emerging Asian and African economies. So the Institute is also one of the founding members of the International Commercial Dispute Prevention and Settlement Organization. And the Secretariat is currently based in Kuala Lumpur, Malaysia. So ladies and gentlemen, with that said, now I will move on to the next part of my presentation on the effects of the pandemic on arbitration. As you can see highlighted on my screen right now is that there are several key points which I will go through later. So despite the occurrence of the pandemic, actually, past year has witnessed a significant increase in the number of registered arbitrations and high value claims reportedly by many institutions, including the ICC International Court of Arbitration, the London Court of International Arbitration, LCIA, and others. For instance, the LCIA in its casework report for 2020 released a statistic showing an exceptional year indeed and gradual internationalization of arbitration cases. This means that there's a gradual movement towards parties choosing one arbitral institution alongside with other international seats and governing laws. With that growing case loads past year, there is also the focus on gender diversity in arbitral appointments and proceedings. And there are more initiatives also made to draw candidates from different pools seeking to avoid too many repeated appointments, while encouraging more first-time appointees and arbitrators from different ethnic and regional backgrounds. Aside from the above, the impact of the COVID-19 pandemic on the institution and its users also moved towards the adoption and conduct of virtual hearings in arbitration. This will be further elaborated in my presentation to follow. So ensuring accessibility to dispute resolution in the face of the global pandemic is also another aspect of consideration. While in the face of this pandemic, many institutions actually step up to enable continued access to its leading dispute resolution services and joined arbitral institutions from around the world calling for solidarity and cooperation. I quote from ICC Court President, Mr. Alexis Mort said, as a recognized leading arbitral institution with global reach, they are proud to join the arbitral peers and to continue efforts to provide certainty and recourse to trusted dispute resolution services at this volatile time. So institutions amid the pandemic also released protocols and guidance notes outlining a range of measures to help mitigate the effects of the COVID-19 pandemic on arbitral proceedings, providing support to parties, counsels, and arbitral tribunals to ensure fair and timely, efficient resolution of disputes. There's also a move towards further modernizing the facilities, premises, and enhanced rooms with technology and equipment adaptable for physical presence, virtual or hybrid hearing. So many events and competitions now, as you can see in pertaining to arbitration, has also shifted to a virtual or hybrid form to ensure access to professional development and networking opportunities. So many hosted the very first fully virtual or digital moot competitions or events bringing together ADR practitioners, users, students, counsel, and academics from around the world. While there have been more revisions and amendments as well to rules, including adoption of expedited procedures on arbitration, have been looked into in making arbitration even more attractive, both for large, complex arbitrations and for smaller cases during the pandemic. So in effect of the arbitration, strengthening global presence, business excellence, as well as raising awareness are the key to provide effective alternative dispute resolution methods to innovate the arbitral processes. So above all, we can also note that there's a possible trend, in fact, towards the adoption of dispute prevention and settlement mechanism, such as the mediation with the coming into force of the United Nations Convention on International Settlement Agreements resulting from mediation, also known as the Singapore Convention on Mediation. It was launched in 12 September 2020 amid the pandemic. So the non-confrontational nature of mediation will naturally steer parties towards dispute prevention and settlement while maintaining the relationship. So the focus after the pandemic now should be first, let's fix the problem, rather than first, let's put the blame. So mediation can help parties, in fact, to reach an amicable settlement quickly and inexpensively, often with minimal damage to their overall relationship. So mediation and negotiation, on the other hand, in cross-border projects, has significant benefits as standalone dispute prevention mechanism or part of hybrid dispute resolution mechanism. For instance, through up, which means that in the midst of the arbitral proceedings, you have this mediation process going on in order to achieve settlement. Such ADR form is instrumental in giving assurance on international trade, besides allowing users to enjoy the flexibility and efficiency of mediation and the finality and enforceability of arbitration. So preservation of the business relationship is important in my point of view, and mediation would be a popular choice among users as a flexible and cost-effective process, which draw attention to its business-friendly characteristics. At this juncture, I'm also pleased to announce on the establishment of ICPACSO with a commendable philosophical approach to front-load the risk as a preventive measure in bringing stability to parties' interests while ensuring a just and fair result for settling dispute amicably through dispute prevention and settlement. So this is pretty essential during this time of pandemic. So next, I'm going to explain more on the online dispute resolution. So last year, 2020 has also witnessed the birth of the online dispute resolution mechanism consequential to the emergency of pandemic COVID-19. So in most countries, including Malaysia, court closures have become inevitable during the pandemic, with many states and federal facilities shutting down for weeks, for months, beginning since March 2020. has not only delayed the progress of numerous cases and projects, but created a backlog that has only slowly been addressed throughout past year. So with parties on all sides looking to recoup the lost time and a cost from the pandemic as well as their case, some will opt to settle to more quickly resolve these matters. In other words, the ADR may be the resolution in times where courts are unable to preside. So many institutions across the globe have now introduced virtual hearings, as I've highlighted above, online proceedings protocols in arbitration, adjudication, as well as mediation, to ensure efficiency and effectiveness in resolving or settling disputes. While this actually includes the Chartered Institute of Arbitrators Guidance Note on Remote Dispute Resolution Proceedings, which was designed to provide the parties with all the tools and techniques for conducting dispute proceedings in full compliance with the social distance regulations. It also provides for guidance on technology and logistical, legal, and procedural matters relating to virtual hearings. Other than the CIAP guidance notes, there's also ICC guidance note on possible measures aimed at mitigating the effects of the COVID-19 pandemic, which was released last year, providing for a checklist for a virtual hearing protocol that will ensure each party is treated equally and given full opportunity to present its case. Not forgetting the sole protocol of video conferencing in international arbitration, providing the best practices for a virtual hearing, as well as the HKIAC Hong Kong International Arbitration Center guidelines for virtual hearings on practical guidelines relating to matters such as the confidentiality, preparation of electronic bundles, and as well as transcription and interpretation services. So it's without a doubt that the world is now heading towards exploring efficient and economical ways to dispense justice in the international commercial spectrum. So as the pandemic persists, I'm sure that it will speed up the progressive transformation in the area of ADR. So according to the 2021 International Arbitration Survey conducted by the Queen Mary University of London, so it was revealed that in circumstances where a hearing could no longer be held in person, 79% of the respondents would choose to proceed at the scheduled meeting or hearing virtually, with only 16 of the respondents that reacted that say they would postpone the hearing until it could be held in person, and the remaining 4% suggesting that they would proceed with a document-only award or arbitration proceedings. Despite the majority preference over virtual hearings, there are few considerations, in fact, to the conduct of virtual arbitral proceedings. Well, the first one being the efficiency. So even though the virtual platforms could save our time and cost, there are practical concerns over the administrative and logistical support for virtual hearings. With the fallibility of technology and the phenomena of screen fatigue, so technology may be advantageous for long and complex arbitration involving numerous weaknesses. So this will have to revisit in terms of having virtual hearings for long and complex arbitration proceedings. Another aspect is in terms of confidentiality. So the adoption of virtual conference technology actually gave rise to the issues of confidentiality, privacy, and as well as security. So in light of these issues, the parties actually should consult with a tribunal in order to establish whether the hearing will remain confidential and making the necessary arrangement in ensuring the privacy and security of the proceedings. So the proper conduct of a security, if there is any breach to the security system throughout the virtual hearing, will set forth rules for parties to remedy it, and as to how parties can enhance the security by express prohibition on recording without permission or limiting the attending number of people only to those strictly necessary should be implemented for virtual hearing. So in terms of a perspective on hybrid hearing, there's also a post-pandemic preference of a mixed in-person and as well virtual hybrid format for almost all types of interactions, which includes meetings and conferences. However, wholly virtual formats narrowly preferred only for procedural hearings, but they are nonetheless preferred to keep the option for in-person hearing rather than a purely remote participation, with only a quarter of respondents preparing to forego in-person hearings as a feature. So we can foresee in the future, disputing parties are more likely to conduct their hearings in a hybrid mode, departing from the orthodox hearing practice format for better flexibility. However, without overturn some aversion to fully go virtually remote, but retaining some sort of important features that enshrine in in-person hearings, such as witness testimony. So that's also a difficulty in having a fully virtual hearing, where the arbitrators may not be able to determine the demeanor and body language of witnesses during virtual hearing. So that's also another concern on witness coaching in a completely remote hearing. So of course, some suggestions have come up to prevent witness coaching and communication by proposing the solutions of having 300-degree cameras or neutral third party to scrutinize the witness in the same room. So this would be some of the proposed solution, but of course, it's always better to have a hybrid format of hearings. Another issue that we have to take note always in terms of hybrid or virtual hearings is the connectivity issues. We have people joining from different regions, so the connectivity would be an element that has to be sought out before we have the hearing go on. All right, in anticipation of the move towards the remote hearing, I understand that the Parliamentary Standing Committee, PSC, of the Department of Personnel, Public Grievances and Law and Justice in India had tabled its 103rd report on the functioning of virtual courts and digitalization of justice delivery in Parliament. In line with the above development, of course, in terms of international arbitration, the arbitrators should also ensure that the arbitration proceeds fairly and smoothly by performing the following. Well, firstly, to manage the hearing and case management efficiently, balancing the conflicting requirements of streamlined proceedings and due process. Well, secondly, to act in accordance with reasonable standard of fairness and equal treatment when there are no definite international rules as to how and when due process should be observed in the arbitral proceedings. So on a similar note, the various protocols and as well as guidance notes, which I've highlighted earlier, would be applicable and are relevant in your studies. So to provide, and thirdly as well, to provide for clear procedural orders addressing aspects of virtual hearings. All right, this will prompt the parties to consider all the issues and reduce the problems of misunderstanding, and as well as, most importantly, possible challenges due to the unaddressed grounds later on during the enforcement process. So the COVID-19 pandemic has acted as an accelerator, in my view, for an increased digitalization of proceedings, as now community has turned to virtual hearings hybrid form, which are common. All right, this provides opportunities, in fact, for mitigating the carbon footprint of arbitrations. This is a future consideration, in fact, forging a path for sustainable change in the way arbitration is conducted. Well, unsurprisingly, the reduction of air travel, the use of electronic correspondence, the offsetting of carbon emission, the avoidance of e-waste, and the increased use of e-discovery capabilities has created the sustainable behavior in the conduct of arbitration. So following the pandemic, it is expected as well that the traveling and in-person hearings will resume to an extent. However, given the widespread and irreversible shift in working patterns, which we have now followed, and given the potency and success of the available technology to conduct virtual meetings and e-bundles, so it's likely that in the conduct of virtual hearings will remain common after the pandemic, and the use of paper and other single-use materials will be further reduced. So moving on the next focus, I will now discuss on the several development and impactful judgments in the fields of arbitration, particularly from the Indian perspective jurisdiction, Malaysian jurisdiction, UK, Australia, and Hong Kong. So I'm going to start with the one in India first. So in a bid to make the legal regime international and arbitration friendly, India has actually amended, as I understand, is that its principal legislation, the Arbitration and Conciliation Act 1996, over the last 5 years. So the most recent one, the Arbitration and Conciliation Amendment Ordinance 2020, came into force on 4th of November 2020, seeking to address the concerns raised by stakeholders after the enactment of the 2019 Amendment Act. So the 2020 amendment arguably settles the debate from a procedural aspect by formally acknowledging the maintainability of an application for stay of enforcement on the grounds mentioned in the newly added provision to Section 36(3) of the Act, irrespective of when the application was filed, in conformity with the earlier decisions in BCCI Kochi and Hindustan Construction against Union of India. So the 2020 amendment also addresses the concern on the qualification of foreign arbitrator due to the limitation imposed by the Schedule 8 of the Act. So the 2020 amendment removes the 8th schedule altogether from the Act, replacing it with the regulation, which hopefully will ensure inclusivity through diversity on the qualification of foreign arbitrators. So in India, settling a much litigated issue, the Supreme Court of India recently in April 2021 decided that 2 Indian parties can actually choose a foreign non-Indian seat of arbitration. Some courts had previously held that at least one party had to be a non-Indian person or company for such a clause to be effective. While now the position is clear, where the Supreme Court had clarified the position that an award issued by an arbitral tribunal in such circumstances would be enforceable in India, and the parties could seek interim relief in India. So the judgment in PASL Wind Solutions Private Limited and GE Power Conversion India Private Limited followed from an appeal from a decision from the Gujarat High Court, actually. It involved 2 Indian companies, one a subsidiary of a French company that had entered into agreement for the sale of converters. So the agreement provided for arbitration in Zurich under the ICC rules and was governed by Indian substantive law. So the tribunal actually issued an award and GE Power applied to enforce it in Gujarat. So Gujarat High Court held that the award was enforceable, notwithstanding that the 2 Indian parties had chosen a foreign seat, but also held that parties to such arbitration would not be entitled to interim relief in the Indian courts. PASL Wind Solutions then appealed to the Supreme Court. The Indian Supreme Court took into account the public policy concerns while promoting the use of arbitration and struck its best to strike a balance between the parties' legitimate commercial interests and the public concerns. In fact, the court emphasized that the parties' autonomy in deciding the seat of arbitration and law to secure their commercial interests, while asserting that the public is not affected in any way in allowing such a decision. So it was held that the 2 Indian parties then can arbitrate outside India, and the resulting award will be valid and enforceable in India. So thereby, this judgment actually created a more arbitration-friendly ecosystem in the Indian jurisdiction. Following from the clarification made by the Indian Supreme Court regarding the restriction in Section 28(1)(a) of the Indian Contract Act as well, the Indian parties now are allowed to opt for a foreign law to govern their substantive contract. So in other words, the restriction to follow Indian law for arbitration seated in India only applies to domestic arbitration instead of international commercial arbitration, even if they are seated in India. So therefore, an Indian national who stays for long term in that country or an entity whose central management is in India can now choose for their arbitration seated in India to be decided in accordance to a foreign law. All right. So now I'm moving on to the recent judgments in the field of arbitration from the Malaysian perspective. So in Malaysia, I'm showing you 2 cases. So I'm going to explain on the first one on Jaya Shude. So in Malaysia, there have been a recent judicial pronouncement on anti-arbitration injunction. So this raises, in fact, the legal conundrum on the efficacy and efficiency of arbitration, besides the role of national courts in arbitration in Malaysian jurisdiction. It is well noted that the degree of court intervention is significant in determining a safe seat for an arbitration. This is propounded in the London Centenary Principles. while a measured approach should in fact be adopted by the court when exercising the power to intervene in arbitration in contemplation of the arbitral bedrock principles of competence, and party autonomy. While this federal court judgment of Malaysia in Jaya Shude, Anak Lelaki Jaya Remt, and Nautical Supreme Sdn Bhd held that a third party of an arbitration agreement was entitled to have its proprietary claim heard first by restraining the parties to the arbitration from proceeding. So the federal court essentially granted the anti-arbitration injunction to prevent a non-party of an arbitration agreement to prevent the arbitration from proceeding. So in terms of brief background of this case is that it actually factually concerns a dispute over a shareholding of a joint venture company formed to build, own, and manage tugboats and provisions of harbor tugs services for a project. All right, the shares were owned by the first and second respondent. Due to alleged breaches, the respondent then referred the dispute to arbitration pursuant to their arbitration agreement. So the applicant for the anti-arbitration injunction in this case was neither a party to the arbitration agreement nor the ongoing arbitration proceedings. It was alleged that the continuation of arbitration without him as a party would impinge his proprietary right over the shares and oppressive, vexatious, and unconscionable conduct. So the contention that he had was that he had a collateral understanding with one of the respondents to the arbitration proceedings, and that he would be given a shareholding in the joint venture company, which is now a subject matter of the arbitration proceeding. So the federal court, in receiving this third-party application, granted an arbitration injunction, reversed the Court of Appeals decision, and held that the delimitation of the court intervention under Sections 8 and 10 of the Malaysian Arbitration Act did not apply to non-party to the arbitration agreement. So it was also held that the stringent test laid out in the English court in J. Jarvis for granting whether injustice will be caused to the claimant would not be applicable. Rather, the fairest test to adopt is a general test in granting interlocutory injunction as propounded in the Malaysian case of Gerald Francis. So this decision was in fact an incredible and landmark decision, which I would say happening in Malaysia right now, because they are suggesting that a third party can now apply to the court to restrain or injunct an arbitration proceedings that is ongoing between parties to an arbitration agreement. So we will now look for whether there has been any development further after this decision has been propounded. So another decision that I'm going to highlight to everyone today in Malaysia is the case of law called Hua and Persatuan Kanak-Kanak Plastik Selangor and Wilayah Persekutuan. So this decision or judgment was actually held in April 2021, which allowed an application to set aside an award on the basis that the arbitrator apparent bias resulted in the award being in conflict with the public policy in Malaysia, and the breach of rules of natural justice occurred during the arbitral proceedings or in connection with the making of the award. So in doing so, the learned judge actually adopted the English landmark decision in Halliburton in deciding that an arbitrator's failure to make disclosure is relevant to assessing whether there are justifiable doubts as to the arbitrator's impartiality. So the court also considered the applicable test for arbitrator apparent bias in Malaysia and restated that real possibility of apparent bias test approved by Lord Hodge in Halliburton is applicable. So having considered the above, the judge was satisfied that the arbitrator's failure to make full and timely disclosure was material to the outcome of the arbitration and eventually set aside the award of the arbitration. So now moving on to another spectrum of the judgment in different jurisdiction, we will now look into the United Kingdom's UK case, English case law of VTB and as well as Melford. All right, VPT is actually recently published, our judgment released in around June 2021, which is this month, All right. Essentially, in this case, the court actually made a final interim anti-suit injunction and refuses the defendant's plea to exercise discretion. So the court essentially held in this case that a party will ordinarily be entitled to an anti-suit injunction to restrain proceedings brought in breach of an arbitration clause. While an anti-suit relief is discretionary, the courts would not likely refuse an anti-suit injunction where there's a clear breach to the arbitration clause. So the decision is actually helpful exposition of the existing principles governing the English court's discretion in terms of anti-suit injunctions. All right, there's another case law that is recently propounded in June as well, English case law in Melford Capital, where you can see the significance of it, which I've highlighted. So the English case law in this Melford case, actually High Court resolved that a prima facie conflict between two dispute resolution clauses in an agreement, one providing for exclusive jurisdiction of the English courts and another providing for arbitration, is in favor of the arbitration clause. So the court interpreted the exclusive English jurisdiction clause as providing the supervisory jurisdiction of the English court. So in giving effect to the agreement of the parties to arbitrate their dispute by referring to the supervisory jurisdiction of the English court. So this decision is welcoming as well in terms of English case law because it illustrates the desire of the English courts to uphold arbitration as a chosen means of resolving disputes among commercial parties, while likely to intend their disputes be resolved in the same forum. So now moving on to another perspective I've included. All right, this is on Australia, the left-hand side, and Neptune Wellness Solutions. All right, this is a case where it shows that the Federal Court of Australia actually continues to enforce the Australia's pro-enforcement approach to foreign arbitral awards. All right, the judgment was released on about June 2021 as well, a recent judgment by the Federal Court, which affirms that the court's pro-enforcement approach under the regime of the New York Convention. So in Neptune Wellness Solutions, the Federal Court applied the New York Convention regime in an efficient manner that aligns with the best practices of ancestral law, model law jurisdictions, and demonstrate the support that the Australian courts will have towards the enforcement of foreign arbitral awards. So in this case, the counsel for Neptune actually appeared remotely, and the application was based predominantly on affidavit evidence. But even though the opponent party did not appear, the learned judge actually declared that the Neptune was entitled to have the award recognized and enforced against them. So parties to arbitration agreement should note that the failure or refusal to appear in enforcement proceedings before Australian courts will not hamper the enforcement of an award. So this will most likely contribute to the rise of the pro-arbitration scene in Australia. All right, another one that I'm highlighting is in terms of Hong Kong jurisdiction. So this decision, as well as a recent decision in June 2021, in the case of C&D, so the High Court here confirmed that the questions around escalation mechanism for arbitrators to resolve and not the court. So what an escalation agreement mechanism is actually clauses contained in many commercial contracts requiring parties to take certain steps before formalizing the arbitration, such as requirement for you to negotiate in good faith before starting agreement. So the court in this case actually made clear that this kind of escalation clauses or any issues pertaining to that shall be resolved by the arbitral tribunals and rather than referring to the court jurisdiction. So the court made clear, in fact, as quoted, the fact that a condition is regarded as going to admissibility rather than jurisdiction does not mean it is unimportant. What it does mean is that the arbitral tribunal has jurisdiction and may deal with the question as it sees fit. So now the tribunal may, for example, choose to stay the proceeding to allow time for compliance, order some form of cost sanction to account for breach, or even dismiss the claims outright as inadmissible. As the court observed, this approach is considerable advantages because the tribunal chosen by parties is likely to be well placed. All right. That would be it on my recent developments and judgments in the field of arbitration. Well, now I would like to share in view that the participants today, as I am aware, are mainly students and as well as young practitioners joining from different regions, especially in India predominantly. So I'm going to share a little bit about how you are going to pave your career path as an ADR practitioner, and I hope that it will be more, relevant and beneficial to everyone's understanding. So as I mentioned, paving your ADR career path is actually a process and not a one-stop option. All right. Generally speaking, regardless of which mode of ADR that you're interested or you want to pursue, you need to have flexibility and opportunistic and commitment. All right. Most of the qualities and skills set required are similar across the various modes of ADR, including arbitration that we're talking about here. So, of course, I'm going to highlight several of the required qualities and skills if you're thinking of venturing into arbitration. All right. The very first is evaluation and decision making. So during ADR proceedings, parties might raise challenges and highlight issues, or even during this pandemic, you will have to have a good evaluation decision making in order to pursue a career in that. Of course, this is true experience. You will slowly gain that. There will not be any precedence, in fact, on some issues of flexibility coupled with judgment skills. This is through more and more involvement in the areas of ADR and practice. Another is planning and management. ADR processes are more akin to project management with different timeline and considerations. So for instance, if you're talking about arbitration, you have the timeline of submission and procedural orders that you have to comply with. So this will require a lot of good skills in terms of planning and management. Be committed and professional. ADR is a notable field alternate to judicial processes. So you need not demonstrate the kind of commitment or akin to that in actual litigation, but you would have to demonstrate necessary skills and professionalisms in dealing with ADR matters in terms of knowledge and approaches that has been adopted. Another is critical thinking skills as well, interpersonal skills. You'll be dealing with parties and different stakeholders along the line. So interpersonal skills is very important. Other than that is listening skill. Pay close attention to what is being said in order to evaluate information and determine the disputes that you have in hand. Reading skills as well, distinguish the important facts from large amounts of complex information that are received. Writing skills, of course, for arbitrators, you will have to write a word. For counsels, you have to prepare the proceedings of papers. For any academicians interested in ADR, they'll have to write a lot of academic writings as well as publications. So writing skills is essential in order for you to deliver the message to your audience or readers. So how to get involved and how I can build a little bit tips before I end my session today is that with regards to methods and tips in building a career, although there's no age restrictions in ADR or timeline for you to venture on ADR. In fact, everyone being junior and students, if you're junior or students, then you're starting it very early. So for those more seniors, not be afraid because there's no age restrictions for entry into ADR practices. But it's always good to get to know ADR early, such as like participation in this national bootcamp would be one good example where you will gain a lot of information. Well, if you're students, it's also for you to participate. I would encourage you to participate more in competitions as well, such as the William C. International Moot competitions. So this will help you to gain deeper understanding as to the practical preparations that is required in terms of arbitration. All right, and as well as the writing skills that you need to polish along the line. Of course, is the advocacy skill at the end of the day. All right, as well as, be a member, sign up for membership with any of the ADR institutions around the world. You can gain a lot of networking opportunity and connections as well as exposures to events, as well as other modes or information that's available from the institutes itself. For fresh graduates or young lawyers who are working in the field of legal right now, planning to find a chambering place or a firm or workplace with dealing with ADR. So that would be preferred if you think that ADR is one mode which you want to venture into. So of course, locate and find a place that will provide you such an exposure. All right, learn from your seniors or partners on how to conduct the actual proceedings. And the earlier choice of career would usually stir your career path, and you can progress well if you have the passion in the work that you're doing. Okay, other than the career choices, of course, you may also pursue certification courses. You may also pursue courses conducted by university or even institutions. All right, for instance, AIARD do provides a lot of courses and training, which will make you eligible for a membership at the end of the training, and as well as expanding or improving your knowledge in terms of ADR. So this kind of trainings by institutions, for example, are conducted by ADR practitioners. So it will be more practical in a way, which means that you will be given a more hands-on, more practical guidelines and guidance as to how ADR is going on. All right, and then, okay, now it's that, with that say, it's pertinent for me to share also the categories of membership of ADR currently offering. Okay, so I'm just going to highlight to you, by becoming a member to the Institute, you will gain all the opportunities to network with fellow members, experienced members of the Institute, and participate in international conferences, events, seminars, which are hosted, jointly organized, or even endorsed by our Institute. All right, and then you'll be given a special rate as well if you're a member of our Institute in joining these events. You can also accelerate your accreditation by joining our courses and gain the post-nominals of being AIADR, FAIADR with an international professional body. So these are also one of the benefits. As you can see, we have different categories. For beginners, you will be associates. For more experience, we'll be fellows. Currently, we have a lot prominent fellow members from different jurisdictions and across the continents. So that would be our membership benefits, just for a highlight. And if you are interested, you may visit our webpage at aiadr.world/membership segments for more information on one-step online application. Otherwise, you may also email to us at the secretariat@aiadr.world for any inquiries. So in conclusion, before I move on to my last slide on thank you, is that India is presently known as one of the most important players in the global economy, in fact, landscape. So its trade policies, government reforms, economic strength has attributed to its standing as one of the most sought after destinations for foreign investment in the world. With that said, in the modern world of cross-border transactions, arbitration provides elements of neutrality in terms of location, governing law, and constitution, made it more attractive proposition in international commercial industry. So the current pandemic has brought several new issues to the fore. So the situation serves as a great opportunity for arbitration practice to figure out the intricacies of information and communication technology usage. Not only that, the present development also possesses a tendency to upgrade the physical arbitrations as we know in and turn it into virtual or hybrid arbitrations from the status quo. So in conclusion, the key factors behind choosing a seat, whether in Malaysia or in India, for both institutional or arbitration, ad hoc arbitration, are highly associated with the judicial treatment and developments of arbitration in each jurisdiction, which I propounded earlier in terms of the judgments that's going on. So users are more likely, in fact, to continue to be attracted by the arbitration-friendly legislative framework and supportive courts, along with the existence of a thriving arbitration hub. So the pandemic has at its best facilitated the virtual and more efficient dispute resolution and prevention mechanism, not forgetting, across the globe. As quoted from Charles Darwin, theory of evolution by natural selection in its origin of species is not the strongest or the most intelligent who will survive, but those who can best adaptable. Thank you so much.
Now, I would thank you so much, ma'am, for this insightful session. And now I would like to request participants to, if anyone had any question, kindly raise your hand, please.
Or they can put questions in the chat box as well.
Yes, I am going to share with you my email address in this chat box as well, so that if you have any queries or if you are interested in any of the issues or matters, you can actually email me directly. And
So I think no questions so far, and I believe that your lecture is cleared the questions doubt in the mind of participants. So now I
I
can
think we
relate.
can. There is a question of.
Okay.
Yes, there is a question. Yes, Akshay.
So there is no question in the chat box, I think.
Okay. Then in that case, I think I'll put that to you.
Yeah,
No?
yes. We'll share the email ID of ma'am to
No,
participants.
no.
Okay, okay, okay. Oh, there's a question. Interim injunction arbitration in same interim order in civil procedural code.
sorry, can I get your questions again?
Yes, ma'am. Interim injunction arbitration is same interim in order in civil procedural code. What are your views on the same?
Let me phrase this for you, Hidar. Basically, this is the question related to domestic arbitration, or in particular to the Indian procedural laws, the civil laws we talk about. So the question is, whether the interim injunctions which the tribunal passes has the same validity or authority like the civil court passes the interim injunctions in their matters.
All right. So just to clarify, because now there are two perspectives of injunction in arbitration. One is anti-suit injunction, and one is anti-arbitration injunction. So there's a fine difference between both. Is that anti-suit is basically to restrain the conduct of court proceedings from proceeding while the arbitration is ongoing. But anti-arbitration, on the other hand, is basically saying that you should not proceed with the arbitration when the court is proceeding. So there's a fine line between these both distinctions. And of course, right now, in terms of anti-arbitration and as well as anti-suit arbitration injunctions, both in the Malaysian jurisdiction, for instance, are governed by the court. So they have the jurisdiction in granting both injunctions. And as well as I highlighted in the Jaya Shude case in Malaysia, in fact, there is a tendency of shifting because usually there will be two kinds of tests. We will have the thorough test of Keith Gerald in terms of civil court injunctions. That would be a less stringent test for interlocutory injunctions in civil proceedings. But on the other hand, through this Jasude, what it's suggesting is that for anti-arbitration injunctions applied under the Arbitration Act as well, and as well for non-parties right now applying for anti-arbitration injunction, so that would be a similar test, contradictory to the earlier position saying that there will be a stringent test for anti-arbitration injunction. So I hope that this would clarify your queries to whoever you're asking. Thank you so much.
Ma'am, there is another question. Should I read for you? Because of the pandemic, everyone globally shifted to a virtual platform, and ADR also took a shift to virtual platform. So, in your opinion, what is better, ADR or ODR?
Okay, I need to get your question correct. Because of the pandemic, everyone globally shifted to virtual, and ADR also took a shift to virtual platform. Yes, as I mentioned throughout my lecture earlier, is that now there has been a fully virtual and also hybrid form of ADR or arbitration proceedings going on. So depending on the tribunal constituted and as well as the parties' agreement, usually some of the ADR, they would prefer to have fully virtual in terms of case management only, and they will prefer in-person for hearings. So this is because of the witness coaching issue, as well as the demeanor and as well as the considerations that the tribunal and parties would have. So in my point of view is that, of course, we foresee that there will be a foreseeable shift in terms of online dispute resolution, all right? But at the moment, I think that the hybrid form would be preferred, in terms of maintaining that assessment and as well the consideration by the tribunal throughout the proceedings. Yes, thank you.
Thank you, ma'am. I think there is no more questions now. And now I can relate with the quote of Charlie Brown, goodbyes always makes my throat hurt. And wow, what a wonderful session and a great event. It has been my great pleasure to moderate this session and work for this boot camp. And I express my heartfelt gratitude on behalf of our organizing committee, Amicus Curiae, the Law Club, and entire law department of JCRC University to take this opportunity to thank our distinguished speaker, Ms. Hidari Jingwa, for giving their valuable insights on the topic. It was a very insightful session, ma'am, and we are indeed and grateful and honored to have you with us. Now, I would like to request Dr. Namita Jain, ma'am, Head of Department, Faculty of Law, JCRC University, to give vote of thanks and felicitate our guest speaker with e-memento as a token of gratitude and honor. Over to you, ma'am.
Thank you, Akshat.
Yes.
Good evening, ma'am.
Good evening.
Thank you so much, ma'am, for accepting our request and for such a wonderful session on ODR. Please accept this e-memento as a token of gratitude from the whole Faculty of Law and Amicus Curiae Club. And I also thank Asian Institute of Alternative Dispute Resolution for supporting us in organizing this event. Thank you so much, ma'am. Thank you so much.
Thank you so much, Doctor. Our great pleasure to be part of the event as well. And thank you so much for the invitation once again.
Thank you so much, ma'am. Now, I would like to request the participants to kindly fill the feedback and attendance form, which is put in chat box, and you will receive a practice assessment soon in the group. So kindly be there in group and enjoy your Sunday now. Thank you so much. Thank you.
Thank you so much. Bye-bye.
Just Akshat, I would like to add, and being an event coordinator, I would like to thank each and everyone and pay my regards to and gratitudes towards everyone who is a part of this event. So, and whether they have contributed directly or indirectly in the success of this national boot camp. So, first of all, I would like to thank Mr. Basin, Dr. Lalit Basin, to be kind enough to accept our invitation to be a patron-in-chief and embrace the inaugural session. Then there is no word enough for thanking Mr. Sameer Shah, the director of this event, and he has made all his availability to us. In fact, in one of the sessions, there was a clash in between, and he had to cancel his another commitments to be here with us and supporting us. I'm very thankful to Mr. Sameer Shah for his guidance in the journey of the smooth conduct of this event. Now, further, I would like to thank Ms. Neeti Sajdeva for supporting, being a part of supporting the organization, for this event as Young MCAI, and not to forgetting to mention Mr. Dr. Sundar Rajo from AIARD. His presence we have not seen his presence, but without his support, I'm sure that it would not be possible for even Ms. Heather to be here, because he only referred us to Ms. Heather. So thank you once again, and to Mr. Sundar Raju as well. Now, moving ahead, I would like to thank the Dean of the Faculty of Law, JCRC University, who has given me this opportunity to organize this event, and the head of the department, Ms. Dr. Namita Jain, to entrusting me with this whole burden of organizing this event, and she has always supported me in every decision I have taken for this in organization of this event. Thank you, ma'am. Not the less, then I would also like to thank the management of the JECRC University, Arpit sir, the Vice Chancellor sir, Victor sir, and OP Agrawal sir, for being there to support this event and stand there for the Faculty of Law in organizing this event. Thank you, sir. Now, I would also like to thank the members of this Amicus Curiae Club. I'm sure that they have, I have asked them to work day and night, and they have done it. And a great round of applause for all of them. They have really worked hard, and in making this event to be a grand success. I'm sure it is. And not last but not the least, I would like to thank all the participants from the every part of the nation. We have received participation from over 20 law colleges, including the faculties as well as the students. Even the young lawyers who are in the practice, want to learn about the arbitration, were the part of this event. Thank you all the participants, and most importantly, the students of JCRC University being a participant and patiently listening to all the dignitaries. And special thanks to all the speakers that without whom we could not have said that this is a grand success. Thank you all the speakers. Thank you, Heather, and all the prior speakers to this session. Thank you, everyone.
Thank you so much, sir.
I think you have shared the feedback form, Akshay?
Yes, sir. It is already shared in the chat.
So this is again that your feedback is more valued, and it so that we can improve. So kindly fill the feedback form, as well as there will be an assessment form as well, on the basis of which you will be getting your certificates. So kindly fill that form as well. Thank you, everyone.
Thank
Have
you
a
so much.
nice
Thank
Sunday. Yes, ma'am.
Pankaj, all the volunteers and committee members be in the meeting.
Yes, ma'am. Definitely. Thank you, Heather.
Thank you, ma'am.
Happy weekend. Yeah. So I request all the participants to kindly leave. Thank you for your being